Yes, Mr. Gordon.
So I said I'd be moving on to deal with the applicable principles for reasonable notice, trying to avoid repeating matters you've already been taken to, so I'll do my best there, no promises. The appellant has, the appellant has set out the legal principles that they say apply in paragraph 17 of their written case, and we've addressed it in paragraph 17 of our written case. And what I'll try and do is to do it by reference to the appellant's written case and indicate where there are points of distinction. So the first factor, this is page 21 of the hard copy. Date of determination, there's no difference between us in relation to that. You look at the circumstances at the date of the notice. B, fact-specific. Decisions on reasonableness are fact-specific and depend on the particular circumstances. Well, obviously that is correct as far as it goes, but the suggestion, I dealt with this before the break, the suggestion that it's impermissible for the court to have regard to decisions in other cases, in my respectful submission, self-evidently wrong. One only needs to look at the Alpha Lettings case as an example where the court quite sensibly seeks to consider how the facts of its case differ from other cases. Dealing then with the degree of formality, I accept that there is a spectrum, a scale of formality, because that's what you see referred to in paragraph 31 of the judgment of Lord Justice Longmore in Alpha Lettings. Nevertheless, in my submission, whether the agreement has been made or reduced into writing is a key or significant indicator of the level of formality. You've already been taken on formality to Alpha. If I could take you to one other authority where there was a brief discussion about this, and that is the ZL case. So you'll find that in the main bundle at page, the relevant passage is at page 1349. So that should be paragraph 88 of the judgment of Lord Justice Nuji. You should find that there, underground 4, length of notice, and then he sets out there from the judgment of the judge below his discussion of the relevant principles, and then you'll see on the next page power 35 within that judgment, the propositions to be derived from Alpha Lettings. Degree of formality in the relationship is important. A completely formal agreement may itself provide for the necessary notice. The more relaxed the relationship, the less likely it is that the court will imply a lengthy notice period. And then, in terms of
that's not talking about an agreement being in writing. It's talking about the nature of the relationship.
Well, it's also talking about a completely formal agreement.
Yes,
itself.
But it might provide, it might state
yes.
The necessary notice.
Yes.
I mean, how significant is writing to this?
Well, in my submission, it is a significant factor. If you're talking about formalising a relationship, the most formal way that you could formalise that relationship would be by putting that relationship into a written agreement. And the more detailed that agreement, the more formal the relationship.
But as Lord Justice Longmore says, it would probably have its own provisions.
Yes. Well, so I think there's a sort of spectrum here, and at the very top end of the spectrum would be a a very detailed written agreement, which would probably have a term for duration. And then below that, there might be a written agreement with less detailed terms and without a specific period for termination.
But surely whether or not it's in writing and the length of the writing is merely one of the factors to consider in assessing the formality of the relationship.
Yes, but it's a significant factor. When one's looking at whether it has been formalised, the existence of a written agreement, as opposed to an agreement which is where you've had some terms agreed orally and some terms derived from conduct.
So when you say it's a significant indicator, do you mean an indicator of the formality of the relationship rather than an indicator of the appropriate length of the notice period?
It's an indicator of the formality of the relationship, which in turn, depending on whether you accept that that's a good rationale for then applying that as a factor, will then feed into that. And as regards the rationale, I mean, it's not set out.
Would you say sort of the regularity and volume or value of purchases over the 40 years is also relevant to whether it's a formal relationship or not?
No, I wouldn't. I wouldn't say that. I think it's the level of, apart from whether it's in writing, oral, or by conduct, I think it's the level of detail terms that you have agreed for the purposes of that relationship. And if it's in writing and you've got extensive detailed terms, that's going to be more formal than a less detailed agreement, written agreement, and more formal than a less detailed oral agreement. And in relation to possible rationale for this being a factor, there is some indication in this in the citation from the judge at first instance in the ZL case. So on the same page 1351 that we were on, the passage at the end of paragraph 89 says the judge considered the applications of these principles as follows, and then at 164.1, the relative informality of the relationship between the parties is a pointer towards a shorter period of notice. If the parties had really intended a long period, it is more likely they would have formalised the relationship. When one's talking about formalisation of the relationship, I suggest that's language more consistent with putting that relationship in writing. There is I'm afraid, very little other authority to assist in Lord Justice Longmore's thinking, or possible thinking, but I do pray that in aid, because that does, in my submission, provide a sensible rationale for this being a factor. So far as concerns, I mean, while I'm on it, let me just deal with the evidence findings of the judge in relation to this, again trying to avoid duplication. You were taken to paragraphs 9 and 10 of her judgment. 9, which was the reference, you'll remember, to an informal exclusivity being agreed, and then 10 setting out the terms, but without any detail as to whether those terms were agreed at the outset or at some later time, or whether they were agreed orally or by conduct or both. And that lack of detail in paragraph 10 is understandable when one goes on to look at the evidence that the judge had before her as recorded in her judgment. And if I could just pick up in relation to that.
I mean, there's no evidence that they were in writing, is there?
No. No. And there's no, and she, just to repeat again, in paragraph 10, she just simply says the distribution agreement had the terms included the following, but there's no detail as to whether those were terms all agreed at the outset, whether they were orally agreed, or whether they were terms which you derive from the conduct of the parties. But when one comes to look at the...
But you're not saying that they didn't comply with these terms. I mean,
No.
There's no evidence to suggest that these monthly annual sales reports weren't given?
No.
Or nobody cared whether they were given or not? They were given?
No, that's absolutely, I'm not, I'm assuming they were given. It's not an issue for this.
No, I mean, looking at the situation at the time of the notice, this is a description of how their contractual relationship worked.
Yes, that would be fair. But in terms of the evidence that was in front of the judge, if we just go to her judgment, paragraph 56, so in the hard copy, that's page 106. In terms of evidence of fact, she had Mr. Mulder, who was the current managing director. So he joined in 2018. You can see that from, if we just jump to page 108 of the hard copy, paragraph 62, it's August 18. That's when he arrived on the scene, so 3 years after the relevant notice. Sorry, that's also in paragraph 57, my error, it's in two places. And then the other evidence was an affidavit that was put in from Mr. Hans Neven. I don't need to take you to the affidavit itself, but it appears in the main bundle at page 696 of the electronic. And at 697, it says that he joined in September 2014. So in relation to the 40-year relationship, the evidence was limited to those two individuals at the dates they joined. And then at paragraph 102 of the judgment, page 121 of the hard copy, not disputed there was no written contract. Additionally, Mr. Mulder conceded he could not say whether the relationship was fixed and formal prior to 2013, which was as far back as he'd reviewed the documents. So he's doing a review of the documents to determine the terms, and then there's a reference to there not being any dialogue in relation to the operational terms. And then at paragraph 107, there was the reference to the fact that in about 7 or 8 lines down, that Mr. Mulder accepted that in fact the agreement changed over time and evolved as the companies themselves evolved. So the evidence that, to the extent that it matters at all, that the terms were fixed, only went back as far as 2013, understandably, by looking at the documents. And there was no evidence as to whether the terms were agreed at the outset, or whether or not, or whether in fact you could only discover those terms by reference to the conduct of the parties. The reason that I raise that is that what this indicates is a level of informality in terms of ascertaining the terms of the agreement that operated. It's not as if there was even a letter which was referred to, which the parties had put together, reciting the terms of the agreement they were operating under. It was more of a reference to the parties' long-standing conduct. And that is, in my respectful submission, also consistent with the way it was pleaded by BHL, the contract was pleaded, which I'll take you to in the main bundle. It's page 218. And it's paragraph 19.
Is this the amended defence?
Yes. Sorry, I should have made that clear. Starts at 207.
And we're looking at paragraph
19, which refers to the contract was one established by long conduct and orally.
It's page 212, I think.
Yes.
212.
Yes.
So that's maybe where fixed and formal came from. Formal, fixed,
Yes.
and clearly established performance requirements.
So in terms of the fixed, within the judgment itself, there's reference to the fact that it was evolving and that the evidence as to it being fixed only went back to 2013, to the extent that matters at all.
Well, what is your case about whether it does matter?
As to whether,
It does matter.
in my submission, it doesn't. What one's looking at is the formality of the relationship. If the terms vary, you vary your terms from 1 year to the next. That doesn't make the relationship less or more formal. In my submission, if you've got, I'll make the point and then I'll move on. If you have got a written agreement with detailed terms, that's your highest level of formality.
But if you then vary those terms, does that become informal?
No, I don't think it does. If you vary the terms of a written agreement, it doesn't make the relationship any less formal, in my submission.
It does seem a bit of an oddity because if you set up a formal contractual document in detail and choose not to specify the circumstances in which it can be terminated, the absence of specification could be taken more than one way.
Yes. I'm not arguing that it's not quite a difficult factor to wrestle with in the context, going either way in the context of this, of a termination of a distribution agreement. But it is a factor which has been identified on the authorities.
Is it clear at all from the judgment in Alpha Lettings whether there was a basis for, in the cases, for Lord Justice Longmore referring to the degree of formality? I mean,
well, only
putting it rather colloquially, where did he get it from? Because it may have its genesis in the Australian blue metal case, where Lord Devlin, it's at page 1070 in our bundle, contrasts the Winter Garden Theatre case, where there was a license agreement with a formal document for a minimum period. And he contrasts that with the very different circumstances in that case, where the agreement originated casually out of an informal arrangement, and their lordships were satisfied that the agreement was nothing more than an ad hoc arrangement. So that's at page 1070 in that,
yes.
that paragraph on that page. I'm just wondering whether that may be the genesis of the distinction between a formal arrangement and what Lord Devlin refers to as an ad hoc arrangement, or what Lord Justice Longmore refers to as a relaxed relationship.
Yes, I'm just looking to see whether Australian blue's even referred to in
Yes, I don't know.
Alpha Lettings. I don't think it is.
I don't think it. Oh, yes, I'm not.
And indeed, it's. We will come on to it in a moment in relation.
I mean, one can see that in terms of an ad hoc relationship of the sort in Australian blue, and of course the conclusion there was that no period of notice was needed at all.
Yes.
But one can see that in that sort of arrangement, that's the relevance of it.
yes.
But no one would describe the agreement here as an ad hoc
No, I mean,
arrangement.
in mining, in the Australia Blue, it was a mining lease.
It was.
So-
A license.
Mining license, sorry.
Yes.
thank you.
Yes.
So quite a different context
Yes.
altogether.
Absolutely.
Not quite sure how that arises on an ad hoc basis, but
Well, it was a very informal arrangement, apparently. They were adjoining landowners.
my lord and lady, I don't think I can take it much further on that point. You have my submissions in relation to levels of formality, and in my submission, where you don't have a written agreement, where you have an agreement with some terms which evolve over time through conduct, that is not an agreement or a relationship at the high end of formality. Returning back to the list, momentarily find again, in my friend's written case at page 21, the next item that we've got there is length of relationship, and it said that that may be relevant to the question of reasonable notice, and then there is reference to Alpha Lettings at 32, Decro Wall, and then a brief paragraph from Jackson Distribution, then reference at sub-E, subsequent expenditure, which is a reference to significant extraordinary expenditure, may militate in favour of a longer notice period. Now, we submit that in relation to the length of the relationship, that in itself is not a factor favouring longer or shorter notice, and that the authorities that are referred to by the appellant in paragraph 17D do not support any submission that because it's a longer relationship, that must mean a longer notice period.
Well, they don't cite, I mean, to be fair to them, they don't cite those authorities in support of that proposition, do they? It's if there has been a significant initial investment, the length of the arrangement may be relevant.
I may say so, very fair. So maybe I should have taken you to, in line with that, paragraph 24B, which is on page 25. This is where they are drawing the key points together. And there they say that Alpha Lettings and Decro will make clear that the length of the parties' relationship is a relevant factor to assessing what is a reasonable notice period. And what one has in my submission that is not correct, so far as it's being suggested that your relationship, the length of your relationship per se, means you have a longer or shorter notice period. Because if one looks at, we've already looked indeed at paragraph 32 of Alpha, but just to go back to that, in my submission, in terms of a factor, so this is at page 1033, the main bundle, paragraph 32. What you get from this is that the question of the length of the relationship operates in conjunction with the question of investment. So in fact, assuming you've only got initial investment, the shorter the relationship, the nearer it is to the time when you made the investment, the potentially longer the notice period. And the further away you are then that would not be a factor for lengthening the notice period. And the other paragraph, which is the other passage which is relied upon in paragraph 24b of the written case is Decro War at page 377. So if we can turn to that, and you'll find that at page 1123. And we're told to look at paragraphs B to D in Lord Justice Sachs's judgment. 1123. And one can see there that there was reference there to the fact that there had been this expenditure in 1970. You'll recall that this was considered in the passage in Alpha Lettings we looked at earlier, which distinguished Decro Wall on the basis that it had been terminated early in the relationship and before the benefits of the capital expenditure had been realised. And that expenditure is what is referred to in B to D. So it doesn't support any submission that the longer you've had your relationship, the longer the notice period. And indeed, when you just go a bit further down to F, there's, it's put in terms of two reasonable businessmen deciding the appropriate length, determining a relationship for the nature described and involving the work and expenditure just mentioned. And it seems to me no concessionaire would proceed unless he knew the concession could not be terminated by notice of less than 12 months. So I was looking at it at the point of the notice, at the point when notice is given. That makes perfect sense if you've just incurred that expenditure. And is it entirely in line with the analysis? And that would, in my submission, would be entirely in line with the analysis in Alpha. So the length of relationship absent this capital or extraordinary expenditure is not a factor favouring a longer notice period.
Well, Lord Justice Longmore at paragraph 32 in Alpha said, no doubt it is right to lay some stress on the length of the relationship, but I would not myself regard that as in any way critical,
yes,
since businessmen expect to run risks in the ordinary course of business, and
yes,
contrast that with a long-term employee who is served loyally. So he's not going as far as saying absent in investment, the length is irrelevant. He's saying it's not a particularly weighty factor.
Well, nor an indication of which way it might be a factor if it was longer. So, and just, if we could just go back to that paragraph 24b of the written case at page 25. When we get just below B, we get to 24C, there's the contention, remembering this is in the section where the appellants are drawing the key points together. They say the Court of Appeal failed to give proper weight to the very significant length of the relationship. They undertook a comparative analysis and then relied on the 3.5-month period in Alpha Lettings, Plusnik and ZL. And then they say this, D, however, the authorities which the Court of Appeal relied on involve relationships of a far shorter duration than the 40-year agreement between ABI and BHL. Alpha Lettings concerned a 15-year relationship and a ZL only a 3-month relationship. None of these are comparable to the length and type of the relationship of ABI and BHL. We're just focusing for the moment on Alpha Lettings. If, as I submit, there is no point of material distinction to be made for the period of notice for a 15-year relationship or a 40-year relationship. There is no basis on that ground for distinguishing Alpha Lettings from the current case. And their reliance on Alpha Lettings being 15 rather than 40 is needed by the appellants because of the difficulty in distancing the decision in our case from the decision in Alpha Lettings, where, as I've already submitted and won't repeat, there are very strong similarities of the factors as identified in paragraph 36 of the judgment of Lord Justice Longmore in Alpha Lettings. If I go back to the list in at paragraph 17, at page 22 of the hard copy, we have as the next factor importance of the contract, where the contract is more important to the party who's objecting to termination, likely to support a longer notice period. What that refers to is Alpha Lettings at 36, which is the passage which makes the distinction between...
Back in paragraph 24.
No, this is 17.
I'm sorry, I'm back in the list at 17. So the list of principles of applicable factors in paragraph 17 at page 22. I'm sorry. So, references made under sub F to where the contract is more important to the party who's objecting to the termination, for example, as measured by a percentage of turnover. This is likely to support a longer notice period. Well, we've seen the passage in Alpha Lettings at paragraph 36, which made the point that the distinction between Alpha, one distinction between Alpha and Decro Wall was that Decro Wall was 83%, Alpha was 20%, and therefore that pointed to a shorter notice period in the Alpha case. So to the extent that what's being said here is that if you have a low percent, if your turnover in your products that you sell as distributor is a low percentage of your overall turnover, that points to a shorter notice period, then that is correct. And that is a factor that the judge did not take account of in this case. Staying with the list at page 22 of the hard copy bundle, best endeavours, well, I've already dealt with my submissions in relation to why we say whether it's best endeavours or reasonable endeavours obligation to promote, that favours a shorter notice period, so I won't repeat my submissions on that. We then have ability to exit the relationship, and this makes reference to the proposition that the easier it is for the party who's objecting to the termination to exit the arrangements and create alternative arrangements, the more likely a shorter period of notice will be deemed reasonable. And you were taken to the, by Mr. Singler, to the passages in the judge's judgment dealing with exiting the relationship and common purpose, and to her reliance on the Australian Blue decision. If I could go back to the Australian Blue decision, so that is in in the electronic bundle at page 1046, at page 99.
1071.
Sorry, thank you, 1071. So I think what was being suggested was that there was some sort of default position. And in that context, you were first of all taken to the passage halfway down the first paragraph, starting the implication of reasonable notice is intended to serve only the common purpose of the parties. And that's to be determined as at the date of the contract. And then there's a reference to what the common purpose is frequently derived from desire that parties may expect to have cushioned themselves against sudden change. And this, it should just be borne in mind that this is in the context of a mining lease. You may understand why there's references to redeployment of equipment in a moment. And then reference to the sort of notice which the appellants want is one which, in the case used in the Winter Garden case, allowed them to reap where they have sown. Certainly reasonable the contract should not be terminated abruptly when their operations were moving out of an unprofitable phase into a profitable one. Just pausing there, that chimes with the analysis in Alpha Lettings, that if you've had capital expenditure and you're early on in the term, it's a longer notice period. And then carrying on, but the question which the court has to ask itself is whether that is a factor which would have been operating in the minds of the parties at the time when the contract's made. There is no evidence from which their lordships can infer that it would have been. And then there's reference to they happen to be unprofitable in the beginning. Therefore, no sufficient evidence of any heavy initial expenditure which could only be recouped in time. And they cannot infer as the common purpose any requirement more than the ordinary purpose, time to deploy their labour and equipment profitably, and on the other hand, for the respondents to find a licensee. Well, it doesn't take you very far in the context of a mining lease. That's to move their equipment to another place where they can mine.
But is there anything in the first paragraph on that page, page 99, that you take issue with as a general statement?
Yes, because the in terms of the first two sentences, definitely not.
Because none of that's tied into a mining lease. It seems to be essentially saying there's two parties to look at here and their respective interests, the frequent common purpose will be a cushioning against sudden change.
Yeah, it's carefully expressed that frequently derived, but there could be other factors.
Yes.
I mean, for example, just say the distributor was, just say you were dealing with a category of goods or services which required the distributor to enter into long-term contracts himself.
Yes.
Then he would need an adequate period to be able to fulfill his own contractual commitments.
Yes, I mean, I very much take that on board, but I mean, what this is looking at is a determination of common purpose from as at the date of the contract. So they didn't have any evidence as to what parties had in mind as at the date of the contract, and there was certainly no evidence in our case as to what the parties had in mind as at the date of the contract. None is referred to by the judge.
But in 1975, was this the first time that these beers were introduced into the Bahamas?
I'm not sure we know.
One of the troubles is it was all 40 years ago, and there's no one alive, I dare say, now who
Lady, I don't know the
there may
answer
be
to that.
some,
Yes.
corporate memory. Sometimes there is as to were they did they make the market for Budweiser in the Bahamas, and it was all something else before? I don't know. I mean, it's just
Anything's possible, but I mean, if you're going to determine what the parties
But I don't quite understand what you're disagreeing with in this. I mean, you accept that there is an implied term to give reasonable notice.
Yes. I think,
There must
sorry,
be
I
a
thought,
purpose for
yes.
that. 'Cause
I think I'd said that I agree with the first two sentences, which are that you imply a term and you determine the length of what is a reasonable period at the time on which the notice is given. And I'm not disagreeing that if you can determine what the parties' common purpose was as at the date of the contract for the giving of notice, that you could determine a common purpose either in the terms that are said to frequently arise at the end of that first paragraph or other purposes.
I mean,
But
I think
this is a long, I mean, the point I'm trying to get to is this is a very long way from saying that there is some default provision that you assume a common purpose of the parties, that the distributor will be insulated from loss.
but that's not what Lord Devlin says.
But that's not, yes,
I
precisely.
mean, if looking at his words as to the common
No, it's not
purpose
what he
there-
says, no.
So the question though is, do you accept what Lord Devlin, what the board said here?
What, as to the,
What he's saying, he's looking at it objectively, isn't
Yeah.
he? He's not looking at it on the basis of any evidence of common purpose. He's saying, looking at a contract like this, where you're going to imply a term of reasonable notice, what is the purpose going to be?
yes.
And objectively, he says, well, it's normally going to be this, which seems fair enough. I would
Yes, but what he does determine objectively is what's at the bottom of the page.
Well, I think he does it at the end of the first paragraph because the common purpose is one that both parties may be expected to have. So it's not one based on evidence in the case. It's based on an objective assessment, I would think.
Well, except
Which
he's
is-
going on to say, in the second paragraph, there's no evidence from which
No, exactly. So he comes back to what he said at the end of the first paragraph. You're quite right that he doesn't go along with the whichever party was putting it forward there.
Yes, but he
They
does.
their lordships can't infer anything more than the ordinary purpose.
Yes, and that
That
is,
goes back to what he said, really.
well, either it's going back to what he said or it's a
He's applying that.
amplification of what he was saying, which is time on the one hand for the appellants to deploy their labour and
Yes.
equipment profitably.
Yes, I think he's applying that general principle to the facts of this particular case.
But he's not saying that you have to predict at the time you enter into the contract how long people are going to need as and when the contract's terminated to cushion themselves. Isn't he saying what the common purpose at the time they enter into the contract is that as and when you give notice of termination, you look at those circumstances in the market then and work out, given those circumstances at the moment of termination or at the moment of giving notice, what time do the parties need?
Yes, what time the parties need for the
To adjust,
orderly to adjust.
but not to recoup the money that
Yes.
they would have had if the contract had continued.
So to adjust. So, for example, it could be to adjust, to allow the orderly wind down of your business, your, in the case of distributorship, your redeployment of your staff, and if that is part of the objective, to make efforts to start finding replacement.
But you
It's
only
no
know
more.
how long they need to do that once you get to the point of giving
Absolutely.
notice. You can't predict
Yes.
that at the beginning.
I agree with that 100%, yes. I mean, the only point I'm making, given the judge has relied on this so heavily, is it doesn't get her anywhere near
No.
what she found was the factor.
Well, I mean, the reason I asked, I don't see anything in the first paragraph of 99 that's inconsistent with your basic position.
No, that's correct. I was answering the questions in the abstract, so to speak, as to whether, nevertheless, even though it isn't inconsistent, it's actually completely correct. And just to just remind you in relation to this orderly conclusion point. In Alpha Lettings, we just go back to that in the bundle at 1034. Paragraph 38. Having found that the right notice period was at the lower end of the bracket and would fix it for 4 months, the judge then says this should have provided ample time to bring the business to an orderly conclusion, and if this was wanted, to make substantial progress towards obtaining another supplier. So it's the adjustment point. It's the final sentence of paragraph 38. And the previous paragraph refers to the Crawford fittings point, which has some, which was the New South Wales Court of Appeal decision, which has some statements which are on this topic. And if I could just take you to that, it is in the electronic bundle, and the case starts at 1356. And this was a case of exclusive distribution agreement for specialised fittings, and there were restrictions on the distributor seeking to sell competing products, and on appeal, the court, by majority, set aside the judge's decision below that 6 months, on the length of the notice period, and concluded that, in fact, it should be a period of 6 months. And so the majority judgments are 1358, Justice Priestley, and then Justice McHugh on starting at 1359. And if I can pick up his judgment at page 1363, with which, so for some immaterial additions, Justice Priestley agreed. So at the top of the page, there is reference to Australian Blue. And then just below the citation from that, at C, no evidence on which it could be further factor operated in the mines. And the Judicial Committee could not infer as the common purpose anything more than the ordinary purpose. And then, as we've got it there, time on the one hand to deploy their labour. And then at E, there's reference to the circumstances of the Australian Blue case. I don't think we probably need to take any time up with that. And then at just below F, it will often be a common purpose of a distributorship agreement that the relationship of the parties will continue for long enough after the giving of a notice of termination to enable a distributor to recoup any extraordinary expenditure or effort. Otherwise, a distributor would have no incentive to make or outlay additional effort or expenditure for the mutual benefit of the parties. Inability to reap the benefits of ordinary expenditure or effort incurred during the course of the agreement may be regarded as a business risk which a distributor takes when he enters into an agreement terminable at any time. The nature of the business produces a lapse of time between effort or expenditure and earning. A certain amount of such effort or expenditure will go unrewarded whatever period of notice is given. But extraordinary effort or expenditure by the distributor incurred with the actual or tacit authority of the principal is in a different category. An appropriate period of notice can give the distributor the opportunity to exploit any extraordinary effort or expenditure. In principle, therefore, it's difficult to see why that is not relevant to the reasonableness of the notice period. So he's focusing there on the circumstances only where you have got that extraordinary effort and expenditure. And then if we go to 1366, just give me a moment. Yes, at letter E, if you could just read the paragraph that starts the chief purpose of a notice. And then, if I can pick up a couple of other references. At page 1369 at the top, he makes reference to a breach of the best endeavours obligation at just below A, but then he says, thirdly, as I have already said, the purpose of a period of reasonable notice is not to enable the recipient to earn further income, except insofar as is necessary to enable him to recoup any extraordinary effort and expenditure incurred in operating the business. So, in my submission, that's all of a piece with what we see in the analysis in our lettings in terms of orderly wind down of your business, and contrary to the position the judge took, which essentially was that the notice period should be long enough to enable business to be replaced. So our submissions on that, therefore, are that in relation to the ability to exit the relationship, the notice should be given to allow that orderly wind down, but it doesn't go nearly as far as the judge determined with the replacement of lost business. So that I think just leaves briefly to note in the list that appears in the appellant's written case at page 22 of the hard copy, that there's reference to an I to custom and commercial practice, and we don't disagree with that, but there isn't any relevant evidence on that in this case. It doesn't come into play. And J, other factors, cyclical markets may affect the notice period, and that's correct in the fashion industry, where you do work in one part of the year in relation to in spring for the autumn-winter collection. That will be taken into account. Then the last point is in crisis. I don't think that's of any relevance to this case. So I hope that indicates where we differ from the appellants on the principles and why. Then applying that all to the facts of this case, and I think I can probably take this fairly quickly, because I've made some of these points at the start of my submissions. In terms of relevant factors, first group of factors are no restriction on competition, coupled with the fact that BHL was in fact a competitor of ABI, and coupled with the extent of the low percentage of turnover of ABI's products, that all points to a short notice period, and indeed those are two of the three reasons given in Alpha for saying that the period should be shorter than the 12 months in Decra Wall and the 6 months in Crawford Fittings, paragraphs 36 and 37. The second factor is that the distributor was under some form of obligation to promote the products of ABI. That would operate during the period of the notice, and that is a further reason for a shorter notice period. And the third factor is the degree of formality, to which I've just been making my submissions. But regardless of the question of the degree of formality, if one were to look at the position in Alpha compared to our case, the factors which I've identified feature in Alpha led to the decision on term of brackets of 3 to 6 months, and there is no, as I said earlier, no justifiable basis for moving away from that. As regards the factors that the judge relied upon in her judgment, if I can go to that to see whether they should affect that analysis. Going back to page 136 of the bundle, at paragraph 142, first factor was the relationship between the parties spanned a period of nearly 40 years. As I've submitted, that isn't a factor which properly leads to a increase in the notice period or to a fixing the notice period at the higher end, let alone where the judge got to at 15 months. I've made my submissions in relation to formality, to the extent that that properly plays a part. You heard my submissions on that as well. And then factors 3 and 5 all to be taken together. So the common intention of the parties at the date of the agreement, which you found to be led to the inference that due to the substantial nature of the distribution agreement, reasonable to infer that they'd each be afforded sufficient time and compensation to make alternative arrangements without damage to the other's business. So it's difficult to see how that alone would play into a longer notice period, even if there was a basis, which we said there wasn't, for the judge to reach any inference as to the parties' intentions at the date of the agreement. She had no evidence about that. But even leaving that to one side, sufficient time and compensation to make alternative arrangements, but without damage to, in this case, ABI's business. There's the obvious point that the longer that the notice period is, then ABI is prevented from selling products through any other distributor. It's tied to the exclusive distributorship agreement. So difficult to see how that, even if it was a justifiable basis for determining a common purpose, would feed through into any lengthy notice period. And indeed, it appears she's taken 3 with 5, and that reflects her view that a important principle was how quickly BHL would be able to replace the business loss in 15 months, and she's got no basis for doing that. And that then just leaves the factor in relation to the refrigeration. I'm sorry. Yes. No problem.
Thank you, Mr. Gorgie. We, of course, can hear you perfectly well. The problem is recording of the
Yes.
sound.
Yeah, my fault for moving around. Old habit. So that leaves the improvement to the refrigerated section in the warehouse. And I made my submissions on that earlier. I mean, it's essentially made a fairly obvious point that it wasn't, certainly wasn't exclusively for the benefit of the distribution business. It was for the benefit of the business of a whole, of which this formed only part. The Court of Appeal dealt with this topic in the passage you've already been taken to in paragraph 29 of the judgment. We submit that they were right in the view they took. Yeah, I mean, I think in terms of what the improvements were in the refrigerated section, there isn't any findings or evidence referred to in the judge's judgment about that. So we say then taking all those factors together, both the ones which we say should have been applied and those which shouldn't, there is no basis for distinguishing the case from Alpha, and indeed from saying that the period should be shorter and significantly shorter than the 12 months in Martin Baker and in Deckerwall, and even the 6 months notice period in Crawford's, for the same reasons that Alpha said in its case was for a shorter period. And indeed, such was the similarity to the Alpha case of the facts of our case that the letter giving notice of termination expressly relied on Alpha. And just to take you to that, it's in the main bundle at page 919. And at the very letter of the 12th of August 15, the very bottom of the page, in circumstances where the distribution agreement contains no express terms as to the right of either party to terminate, our clients entitled to terminate on providing reasonable notice. And then over the page, having regard to the aforementioned legal authorities, our clients view that a period of 3 months represents reasonable notice, and then that was subsequently extended for a brief period. If the decision in this case was allowed to stand, the decision at first instance, as being within the range reasonably available to the trial judge, it would, in my submission, create significant commercial uncertainty, given the disparity, without, we say, apparent justification, between the period in this case and that in Alpha. So we submit the court was entitled to reach the conclusion it did in paragraph 31, that the judge was outside the range reasonably available to her, and that's sufficient to dispose of this appeal. So far as the grounds that are relied on in relation to the other factors that the Court of Appeal took into account, ground one relates to the formality issue, and I've already dealt with that and explained why we say that the Court of Appeal was right. So far as ground two and ground 5 is concerned, ground 2 concerns the judge's application of a principle she said was derived from Australian Blue in relation to replacement of business loss. We say that she was wrong on that for the reasons I've submitted today, and we put in our written case, and we acknowledge in our written case that those weren't the reasons relied upon by the Court of Appeal, but nevertheless we rely on those reasons. The consequence, if we're right on that, is that ground 5 falls away, because that was the judge's application of that principle to arrive at a 15 months by reference to inter alia, the loss suffered. And in relation to issue 3, that's the obligation to promote the business, ground 3, and we submit that the judge failed to take account of that, and therefore that ground should be dismissed. Ground 4 is the refrigeration factor, and again we submit that the judge was wrong on that, and that should be dismissed. Could I just have a moment? Unless there's anything else I can help you with, we respectfully invite the board to advise His Majesty to dismiss the appeal.
Thank you very much, Mr. Gorge. Mr. Singh.
But just some important points to make. I mean, the first point is it's common ground. The question of what constitutes reasonable notice is a highly fact-sensitive question. It's also common ground that the Court of Appeal was only entitled to interfere with the judge's conclusion if that conclusion was plainly or demonstrably wrong. Now, I'd like to clear away the submission by Mr. Gorgie that one can derive assistance from other cases. He went as far as to say...
Just on the question of it's not just if it's plainly wrong, is it?
No, I'm using that as shorthand, Your Lordship's absolutely right. An error of principle, yes, or outside the range of... Yes, that's
but also irrelevant considerations? Or
yes, no, absolutely. I apologise, I'm using that as shorthand, yeah. And it's common ground, that is that's the basis on which the Court of Appeal had to proceed. Mr. Gorgie made a lot of reference to other cases, and he went as far as to say, well, look at how similar the facts were in Alpha. Now, I'd just like to respond to that point. I mean, first of all, it's actually clear as a matter of authority, but I say in any event, it's right as a matter of principle that other cases are irrelevant, the outcome in other cases. If one needs authority for that proposition, that was expressly dealt with by Lord Justice Nugie in the Zymagorium case, at paragraph 90, which one can see in the Court of Appeal of Bahamas judgment. He deals with this submission and says it's actually irrelevant to look at what happens in other cases. And we say that's plainly right. Let's just turn up page 85 of the hard copy bundle, where the Court of Appeal quoted at length from the Zymagorium judgment. And at paragraph 90, he refers to a decision called Hansard, which he was taken to. And he says, I don't myself find Mr. Justice Norris's decision Hansard of any assistance. As he himself said at paragraph 64, the reasonable length of notice must always depend on the particular facts of the case, so that other cases are of limited assistance.
Well, that's not going as far as saying they're irrelevant.
Well, he then at 93 makes the same point.
It's troubling if they are literally irrelevant, because if you, I mean, I appreciate that because, as you say, it's multifactorial, the factors in different cases are liable to be different. But if you have cases where the factors are the same or broadly similar, you would expect consistency in decision-making, justice,
of course,
to result in similar outcomes.
Of course. The approach taken may be instructive, but one must always be careful to look at the particular facts. And so here, for example, it's a 40-year relationship with a high degree of formality, and I don't therefore accept that Mr. Gorgie's attempt to say, well, this case is exactly the same as Alpha Lettings. For example, in Alpha Lettings, there's no finding which corresponds to the high degree of formality. The Court of Appeal proceeds on the basis that it's a relatively informal arrangement. That's paragraph 31. There's no suggestion in Alpha Lettings of any capital investment that needed to be recouped by the time the notice of termination was served. And also, Lord Justice Longmore concludes at paragraph 38 that the notice in that case, he fixes it at 4 months. That should have provided ample time to bring the business to an orderly conclusion, and if this was wanted, to make substantial progress towards obtaining another supplier. So for those reasons, we do submit that it's not right simply to carry across alpha lettings and say, well, on the fact, this is very similar. And Mr. Gorgie even went as far as to say at one point that essentially 3 to 6 months should have been the starting point for the judge, subject to there being something extraordinary, I think is how he put it. And we say that actually is wrong as a matter of approach. In relation to how the judge dealt with this, could I just ask you to turn back to paragraph 142 of her judgment, where she pulls together the factors that she considers to be relevant to her conclusion of 15 months. And if one just looks at 142, I'd just like to go through these points. The first point, she says that the relationship between the parties spanned a period of nearly 40 years. Now, in my submission, the length of the relationship is a relevant factor, and indeed we say it's a significant factor in terms of what the parties' expectations would have been on an objective basis, the inquiry, as at the date of the notice. Now, it's right to say, in alpha, paragraph 32, Lord Justice Longmore referred to the length of the notice by reference to the capital expenditure. So if the agreement had not been in place for a long time, that might militate in favour of a longer period. But as I think my Lord Hodge pointed out, he also says, no doubt it's right to lay some stress on the length of the relationship. He doesn't regard that as critical. So he's actually making two different points in my submission in paragraph 32. But as a matter of principle, in my submission, it must be right, if one's looking at this as at the date of the notice of termination, and if one's looking at this objectively in terms of what would the parties' reasonable expectations be, I do submit that the judge was entitled to take into account that it's a 40-year relationship. So that's her point one. The second point is the fixed and formal finding. Now, again, just taking that in stages, that's plainly a relevant factor. In alpha, it was described as a very important consideration, and the Court of Appeal in the Bahamas proceeded on the basis that formality was a very important consideration. And you have my submission as to why the Court of Appeal fell into error in relation to formality. They didn't at all refer or grapple with the findings at paragraph 130. Why did the judge, what was the evidential basis for this finding? And then they go on to say she was wrong because it wasn't reduced into writing. So we say the judge took into account a relevant factor, and the Court of Appeal's criticism in relation to formality was misguided. And then the third point she makes is the Australian Blue case. I mean, one can see that that's what she's referring to, because she refers to common intention of the parties, and then the language of each side being afforded sufficient time and compensation and so on. One can see that that comes from her section earlier, paragraphs 126 to 128. And we say, again, this is a relevant point for the judge to have taken account of. And the critical question is making alternative arrangements. I mean, that comes straight from Lord Devlin in Australian Blue. And you have my submission as to why we say, in relation to this point, the Court of Appeal fell into error, because their rejection of what the judge did on Australian Blue was tied to a finding on a different point in the Zymagorium case. So we say, again, point three is unimpeachable, as it were. That's a straightforward application of the Australian Blue principle. Then if one looks at point four, the first sentence, substantially invested. Now, again, we say that's a relevant factor. I would say that's more directly relevant to the question of formality and structure and so on. It's different from the capital expenditure point. But Mr. Gorgie dismisses that as being an irrelevant factor. We say that's not irrelevant. That's part of the assessment. And then the next sentence is the capital expenditure, which on the authorities is relevant. It's not merely capital expenditure incurred at the early stages of the relationship. In fact, it's capital expenditure also incurred during the relationship. That actually, one can see that in the Crawford Fittings case. I don't think one needs authority for that proposition. But the point being, there has been in recent years, as she says, in point 4, some improvement, and leaving aside the focus in the Court of Appeal on primarily for the benefit or otherwise, in my submission, that again is a relevant factor which the judge was entitled to take into account, that in recent years, before the termination, capital expenditure had been incurred, at least partly for the benefit of ABI. So again, nothing wrong with her 4th point. And then the 5th and the 6th points. Now, the 5th point is, she says it's a very important consideration. Now, I accept one could quibble with whether this is an very important consideration or not. But what the substance of the point is the length of the time that BHL was able to replace the business loss and to find a new brand to distribute and achieve profitability. Just before I make my submissions on that, you have my submission on the Court of Appeal's error in respect of the underlined wording. They quoted from the "we believe the separation nets more benefits." So if one's focusing on how the Court of Appeal deals with this, we say they plainly fell into error by ignoring the underlined wording.
But isn't the quote from Mr. Nevin making it clear that they didn't intend to find a new brand, they just intended to promote the value of their own brands? So I'm not quite sure why they need time to do that.
Well, my point on the underlined wording is that the judge here is relying on Mr. Nevin saying there's no question that it hurt our bottom line. And what the Court of Appeal do is they ignore that and they focus on, but we believe that the separation nets more benefits. That's the point I'm making just on the way the Court of Appeal dealt with this. But the broader point, which has obviously emerged through the discussion, is the judge's approach to replacing the business loss. But I emphasise the words "and to find a new brand," because in my submission, what this is doing, or what the judge is doing here, is in substance asking herself a very similar question to the Australian blue alternative arrangements question. I mean, ultimately, reasonable notice has to be provided. And why is that? It has to be provided so as to avoid a situation where there is a sudden and significant adverse impact on the other party. So I don't accept the characterization that what the judge was doing here was inventing a new principle that the entirety of the business lost has to be compensated for. I don't accept that she was going that far. In my submission, what she was doing in paragraph 5 was essentially, it's the same inquiry, the Australian blue type inquiry of how long does the party need in order to replace the business loss and find a new brand, make suitable alternative arrangements, in other words. I do accept in point 6, the reference to Mr. Townend is the more direct question of financial loss. But again, I say that's something which the judge was entitled to take into account as one of a number of factors. So in my submission, on a proper analysis of 142, the judge took into account relevant considerations and didn't make any error of principle. I do accept she didn't ultimately deal with this question of whether there was a best endeavours obligation or some other obligation, some duty to promote. I do accept that, but in my submission, that's in fact not a significant factor. It's given a lot of significance because of the way Lord Justice Longmore dealt with this in the Alpha Lettings case. But in my submission, again, if one thinks about this as a matter of principle, there's always going to be a continuation of the pre-existing relationship during the notice period. Now, in Decro Wall, for example, where the court said a reasonable notice period was 12 months, in the Martin Baker case, where the court held, again, 12 months was a reasonable notice period, during those 12 months, the relationship is going to continue. And so in my submission, it's not right to consider, as Lord Justice Longmore did, that the best endeavours or some duty to promote creates some real fundamental difficulty that always militates in favour of a shorter period. And so therefore, whilst I accept the judge didn't ultimately make a finding in relation to that or deal with that, it's not a significant point in the overall context. So, my lords, my lady, we say if one takes a step back, what the judge has done here is assess all of the evidence in relation to a question that is highly fact-sensitive. She has taken into account a range of relevant factors, and ultimately she has rejected ABI's case that 3.5 months notice was reasonable notice. And so we say the Court of Appeal wasn't entitled to interfere with that conclusion, especially in circumstances where the principal reason given by the Court of Appeal, the first reason given by the Court of Appeal, was their conclusion in relation to formality, which we say discloses a plain error. So, my lords, my lady, unless I can assist any further, those are all the reply submissions I wanted to make.
Thank you very much indeed, Mr. Singler. Well, if I may say so, it's been a pleasure to hear such accomplished submissions on behalf of both parties to the appeal. We'll take time now to consider what's been said and the advice that we will humbly tender to His Majesty.